Welcome, everyone, and thank you for joining us for LawCats Live today, December 3rd. We're thrilled that you've joined us to learn about this really exciting topic. I'm Karen Adam. I'm a double Wildcat, BA and JD, and a 5 years since retirement Superior Court judge. I'm still actively working on the issues that most intrigued me during my 34 years on the bench, and all of them relate to access to justice, equity, and inclusion. I was lucky to assist in one of Professor Butler's I4J classes in the spring of 2019. I went in a complete skeptic, old school, and emerged a complete fan. Today's topic is the power of legal innovation in the COVID era. There is not a lawyer, judge, advocate, administrator, clerk, probation officer, interpreter, jury commissioner, or court reporter whose work has not been dramatically impacted by the pandemic. That is because never have so many court users been literally shut out of the courthouse, no matter how critical their legal issue. And never before has such a tradition-bound institution as the court so deftly and quickly changed the way business is done to ensure access to justice and procedural fairness. Today, we'll learn about innovative projects and processes that helped push the court in the right direction. And now for Zoom keeping details. I don't need to tell you where the bathrooms or exits are or where to get coffee and water. Instead, here are a few pointers that will assist in making this webinar run smoothly. First, questions and answers will take place after the panelists are finished presenting. If you have a question, please feel free to submit through the Q&A function at the bottom of your screen. The chat function will not work for attendees. This webinar will be recorded and posted at a future date on our Arizona Law website. Remember to check the master calendar for upcoming LawCats live events. This webinar will end promptly at 1 p.m. Arizona time. However, some of the panelists are able to remain available for questions until 1:15. Please stay on Zoom if you'd like to further engage with them. Let me introduce you to our fabulous panelists in order of their appearance. 2020 Arizona State Bar Award of Special Merit winner, Professor Stacy Butler, is the director of the I4J program and has 2 decades of experience in community advocacy and expanding the reach of civil legal services for underrepresented populations. Her research focuses on the application of human-centered design and innovation to social justice issues. She's a Tucson native who loves working with the Tucson community. Mackenzie Pish, UAJD 2020, yay, brand new lawyer, is the I4J program manager and has been active in advancing many of its projects. She currently runs its tenant education program, developed the final deliverables for the I4J's program work on meeting the needs of human trafficking survivors, co-authored I4J's usability evaluation of Utah's online dispute resolution platform, and helped create the I4J cost of eviction calculator, an advocacy tool that was a finalist at the Georgetown Iron Tech Lawyer Invitational. Sarah Mauet is a UX, User Experience Initiative, I had to look that up, researcher and strategist. When not collaborating with I4J to change the world, Sarah is the creative director for media and digital technologies at the University of Arizona's Office of Digital Learning. There, she works to make online learning environments and tools more engaging, accessible, and impactful for all learners. Sarah believes that integrating human-centered design into the development process for emerging technologies can help us build more just, equitable, and sustainable communities. Last but not least, Professor Christopher L. Griffin Jr. is the Director of Empirical and Policy Research and a research professor at the University of Arizona, James E. Rogers College of Law. Professor Griffin teaches civil procedure, remedies, and empirical methods in the law. His research empirically investigates whether ideas for enhancing access to justice work or don't. Most of these studies focus on the civil justice system, including the efficacy of unbundled legal services in housing court, the value of connecting survivors of intimate partner violence to civil legal aid, and the potential promise of non-lawyer models of legal services provision. With that, I'm going to turn this over to our panelists, beginning with Professor Butler. The panelists have agreed to, now that they've been formally introduced, use first names from this point forward. Take it away, Stacy.
Thank you for that awesome introduction, Judge Adam. So hopefully my screen is showing. I'm driving the screen share today, and I will try to keep up with my colleagues. I'm going to spend a few minutes just giving you an overview of I4J and what we're up to in the lab, and then turn it over to my colleagues to talk more specifically about some of the projects in the lab that are, we think, particularly relevant to the COVID era. So really, I4J started in recognition of a deep and wide justice gap in this country. 76% of the civil cases in this country before COVID involved at least one self-represented litigant, and 71% of low-income households experience a civil legal need each year. 70% of those will say that their lives are severely affected by that legal problem. But our traditional models for trying to serve low-income populations aren't working. Nationally, legal aid is unable to serve approximately 72% of the people that need and qualify for its services. And it would take 275 pro bono hours from every lawyer in the country to give just 1 hour of legal service to everyone who needs it. As a result, 86% of the civil legal problems in this country receive inadequate or no legal help. No surprise, the justice gap has only worsened in the COVID era. Before COVID, we knew that 1 in 4 civil cases in this country was a debt collection case, and half of those were medical debt. Now, as we begin to emerge from the global pandemic, I think we can anticipate seeing an increase in volume in medical debt cases and consumer debt cases. Before COVID, we saw 3.6 million evictions in this country each year. Right now, an estimated 30 to 40 million Americans are at risk of eviction. Domestic violence reporting has dropped by 50%. That's not because DV isn't happening in this country. We do know that DV is increasing, but what's happened is we have eliminated those safe spaces for survivors to report. Meanwhile, as Karen mentioned, courts have had to move very quickly to technology in the face of a technology gap. Communities of color more often are navigating technology just from a smartphone. That's their only access to the internet. And I think a lot remains to be seen around what this rapid shift to court-based technology means for communities that can only access that tech from the palm of their hand. What that means for I4J is that we can't train the next generation of lawyers for business as usual, and that justice needs innovation. And that's at the core of our work. We are a social justice innovation lab that designs, builds, and tests disruptive solutions to the justice gap. This is what our classroom looked like before COVID. What students learn in the lab is working collaboratively across disciplines, thinking creatively about solution building, working with and within communities, understanding systems level challenges, applying technology effectively, engaging in evidence-based evaluation of their work, and being willing to iterate and pivot. This is what our classroom looks like now. We had to pivot just like everybody else. The lab is now running 100% virtually. It has been a COVID silver lining for me. You can see our Zoom classroom at the bottom, but what this really has opened the door to is a space for students to really connect their personal lives and their school lives and their social justice interests all into one really loving and supportive virtual space. So we're really enjoying the virtual lab at I4J. We have 11 projects right now in the lab. My colleagues are going to share with you 3 of them. And I think these 3 projects illustrate how we've had to adapt during COVID, but also why our work is really important during COVID. And with that, I will turn it over to Mackenzie Pish.
So I'm going to tell you a little bit about the cost of eviction calculator. This is an online free tool that helps communities calculate the cost of eviction by focusing on some of the downstream costs, such as emergency shelter and medical care. By highlighting those costs, the goal of the calculator is to make those costs more transparent and help promote systemic shifts towards eviction prevention. So we started building the calculator in January 2020 before COVID hit to address the pre-existing eviction crisis, which, as Stacy mentioned, affects about 3.6 million Americans per year. Stacy, if you slide to the next one, Tucson, where we live, is a top 25 evicting city with over 10,000 evictions per year. Evictions destabilize families, particularly our most vulnerable families, and cause homelessness, mental and physical health problems, and economic hardship. But evictions also harm communities too. And like every other community, Tucson's attempts to care for evicted families members requires extensive resources, leaving little room to fund eviction prevention. So we rebuilt the calculator to really try to connect the dots on those eviction costs so that we could show decision makers how much was in their wallet to fund eviction prevention instead. The calculator calculates the cost of homeless shelters, medical care, child welfare, and juvenile delinquencies. Users can go to our tool and they can input local data, borrow from national figures, or refer to other localized data. And when they're done, it tells them their total downstream costs, and it breaks down each cost category in a report. But we built this calculator as like a minimum viable product for an international access to justice competition. The plan was really to just prove the concept of the calculator at the competition and hopefully secure funding to improve the calculator's methodology, conduct some local use cases, and improve the calculator's interface through usability testing. We were incredibly grateful to secure funding from a local nonprofit in Tucson that focuses on housing stability. It's Family Housing Resources. And we laid out a plan for them on how we were going to use that funding to really improve the calculator. But COVID hit, and all of a sudden, all of our plans just didn't seem so relevant, but the work that our calculator was already doing, the work that it could do, had new and urgent relevance. Stacy, go ahead and click through one at a time for me, but we have, right now we're looking at tens of million renters at risk of eviction. In October, nearly 16% of renters were behind on rent, and our delinquency rates were even higher for our most vulnerable and marginalized renters. 1 in 4 of our renters have no or slight confidence they can pay next rent on time. And more than half of renters with no confidence are borrowing from family and friends. More than a third are using credit cards, and more than a third are spending down their savings or assets. So our goals to do usability testing and case studies, while they still remain on our list and are still very important, they didn't seem as necessary right now. We really wanted to focus on how can we use the calculator, how can we adapt it for COVID, and how can we help national and local experts in their advocacy right now. So we reached out to experts. We worked with Neil Steinkamp, whose cost benefit studies have launched right to counsel movements in New York City, Philadelphia, and Boston. We talked with Emily Benfer, who is a leading health law and housing advocate, who created the eviction policy scorecard and who has been screaming about eviction since COVID hit. And we worked with the National Low Income Housing Coalition, who actually partnered with us to improve our methodology and co-authored a report on the cost of evictions during COVID-19. And that report was just released a couple of weeks ago. So Stacy, you want to click through. That report, due to the funding from FHR and the partnership with the NLHC, our methodology became a lot more sound, and we were able to produce cost estimates for the cost of eviction for all 50 states and at the national level by leveraging expert predictions of the number of renters at risk during COVID-19. And what's next for the calculator? I mean, we're really just, go ahead and skip through with me, Stacy, but really just trying to remain scrappy. We are going to work on national and local advocacy. We're going to collaborate as much as we can because that has been the most helpful resource for us and the most effective tool. And we're going to just continue improving our methodology and be ready to pivot for what's needed next. And with that note, I think one of our biggest pivots, actually, Sarah Mauet can talk to you about.
Thanks, Mackenzie. Yes, I'm going to talk about another project we did that was impacted by COVID. Last fall, I4J partnered with the Utah State Courts and Pew Charitable Trust to conduct the nation's first UX evaluation of an online dispute resolution platform. ODRs are emerging as a promising strategy for narrowing the United States justice gap, but they must take a UX-focused approach in order to overcome the related technology gaps Stacy mentioned that could prevent them from achieving that goal. So the field of UX, or user experience, is focused on improving the quality of individuals' perceptions of their interactions with a product, service, or system. In order to do that, UX best practices encourage us to understand and involve our users at every stage of the iterative development process, so the final product is useful and usable for the people who need it most. The Utah State Court launched its ODR platform in September 2018. You can go ahead and advance, Stacy, with the goal of increasing access to justice. But a year after launch, Utah Court stakeholders shared with us that the platform had fallen short of their user engagement goals. Only 36% of defendants were actually registering with the ODR platform, and of those, only half were reaching a case resolution. So that's where we came in. As part of the spring 2020 I4J Innovating Legal Services course, we designed a rigorous baseline usability test to evaluate the Utah Court ODR. We invited 8 representative users to complete a realistic set of tasks using Utah's affidavit and summons and their ODR platform on their own smartphones. A facilitator guided them through the standardized script and encouraged them to think out loud as they attempted to complete each task. This enabled us to collect both qualitative and quantitative data about Utah's ODR platform. The baseline tests were quite revealing. We identified quite a few usability challenges, but rather than make assumptions about how to address them, we turned to lived experience experts. We conducted a series of participatory action workshops with 18 members of the low-income community who shared their perspectives and worked collaboratively with us to co-create possible solutions. Using these insights, we then redesigned the affidavit and summons and created an interactive prototype of an ODR platform. Now, at this point, we had intended to fully replicate all conditions from the baseline test for the prototype test, but unfortunately, COVID had other plans for us. That became impossible due to the stay-at-home order issued by the governor in response to COVID-19. So we had to get creative. Luckily, we discovered that 8 household members of the research team met the recruitment criteria for participants in our study. So we distributed testing kits to facilitators to conduct the tests at home. Other than the change of the testing environment, the methods remained consistent. So in this way, we were able to conduct a round of testing on the prototype that enabled us to show the effects the redesigns had on user experience. We have an incredibly detailed finding sections in our report, and I encourage everybody to review it. But the short version is that the redesigned prototype indicated a much improved user experience across multiple usability metrics. Now, it's important to understand usability studies are not meant to rate an initial design. The purpose is to understand the user's experience, find opportunities to improve it, and measure the impact of changes. So equipped with this data, we were able to make recommendations to Utah in 5 categories of changes to align the platform more closely to the needs of its users. Each of these 5 broad recommendations includes multiple detailed, actionable, and user-verified suggestions for achieving the related goals. Some suggestions will be simple and quick to implement. You can go ahead and advance, such as making the URL short and meaningful and non-case sensitive, and redesigning the summons and affidavit with clearer options and a QR code. Other suggestions are a little bit more involved, such as integrating document upload functionality into the chat screen, creating new onboarding tools for first-time users to orient them to the process, and replacing a page that participants had found confusing with a series of brief yes or no questions that guide them to generate their own customizable claim response. We presented the report to Utah stakeholders, and they are going to use all of our recommendations to guide their efforts to improve the usability of its ODR platform before they expand statewide. The most notable conclusion to come out of this report, though, is that users are ready for online courts. When we asked whether they would prefer to use a website or physically appear at the courthouse to resolve a dispute, all but one of the participants responded with a preference for online. We started this work in response to the rise of ODR, but the rate of digital transformation has only increased with the COVID pandemic. This presents us with both a risk and an opportunity. If courts do not engage their users in the design of new technologies, we risk unintentionally transferring the structural barriers that currently exist in our legal system into the new digital tools. However, if we take the opportunity to reimagine our civil legal system along with its users, we can develop fair, just, and equitable online environments that meet the legal needs of all. So as this study has shown, evaluation is essential to ensuring A2J solutions actually work for the people that need them. And at this point, I'll hand it over to Chris to explain how empirical evaluation is built into all I4J projects.
Thank you very much, Sarah. Boy, I appreciate your taking that down. Thank you so much. It's my opinion that the sort of disruptive innovation that the I4J program stands for contains, like many things that we do, both art and science. And I am nowhere near as artistic when it comes to access to justice innovation as my three prior colleagues are. I just bring the science, the stuff that for many people is dull and boring, for others, just something that they would prefer not to engage in. But I'm so thankful that Stacy, from the early stages of the program, has recognized the benefit of rigorous evaluation, because without it, dreaming up an idea and having a good policy to pitch to stakeholders is great, but it's so much better to come in with evidence in hand that there is something to this innovation, that it can actually move the needle and push forward positive improvement in the lives of everyday people. So even with the Utah ODR project, which the four of us all worked on together, Sarah was both the artist and the scientist, teaching the rest of us about UX evaluation. And it really was tremendous to see a different methodology as applied to an access to justice question that all four of us cared about. Pivoting as we have this academic year, still in the great state of Utah, we have been investigating the extent and the features of medical debt as people who are resident in Utah experience it. The students enrolled in the I4J course this semester have been looking at the landscape of medical debt, figuring out where the deepest problems are, and then coming together to work on prototyped versions of possible solutions to that crisis. That's going to feed into a spring semester course that I am teaching. It's formally called Empirical Methods in the Law, but the heart of it is really taking those prototyped ideas and giving a sense, not just to us, but stakeholders in Utah, about whether these ideas are effective. To give you a sense of how this works, especially in an era of a pandemic, the goal as we are setting it out right now is to show that in a controlled laboratory setting, not yet in the field, working directly with people experiencing medical debt in real time, if we simulated what that experience is like, which of these ideas, if not all of them, carry some promise for improving the lives of those experiencing medical debt, so that after we have both come up with a prototype and run it by stakeholders in Utah, then through a simulation show that when people go through that experience, that they might be positively impacted by these innovations, then we should devote the time and the resources for a full-blown field evaluation. Usually it would be the case that we would skip the lab-based one. At least a lot of my other colleagues and I who do access to justice evaluation go from design straight to the field. One of the unintended benefits of COVID is that we can take our time and be a lot more thoughtful and purposive about this, and in a way that would not be cost effective in non-pandemic affected times. We might be able to, we will have as a goal to actually engage Utah residents who fit the characteristics of those who experience medical debt, to see how they go through the experience of what the prototyped intervention would provide. And in that way, we can do it remotely, as we would need to in these times anyway, but engage with them in still a very meaningful fashion before we would then consider setting up an operation in Utah where travel would be involved, where we would actually be influencing the experiences of actual people experiencing medical debt who have live cases. And this will be my first time doing a completely lab-based evaluation. It will be randomized, which those of you who know my work know that I stand very strongly in trying to find opportunities to ethically and legally randomize interventions so that we get our best sense of the causal effects that go along with our ideas. And students will, just as they have this semester, in designing the interventions, they will be directly involved in the conduct and the design of the randomized laboratory-based experiments, another first for me and for the I4J program, to which I'm really looking forward. And I just want to impress, as I normally do as I close out, that for anybody who's thinking about how to change the access to justice space, who has strong ideas for new programs or policies that might positively impact people's lives, don't forget about we scientists out there. We have something to offer besides just a bunch of Greek letters and numbers. And that is, again, the evidence basis for going to philanthropic organizations, for going to courts, going to legislatures to seek more real support, moral and financial, for the ideas that our wonderful colleagues bring to bear. So with that, we'll look forward to your questions.
Karen, I just wanted to take a minute to say thank you to the I4J sponsors who make our work possible. These sponsors help fund things like the technology we take into the field, the technology that runs our classes, student opportunities, both during the summer and during the semesters, and our cost of eviction calculator. So we're really, really grateful for this support from our early adopters. And I think with that, we are ready for questions.
First of all, I just wanted to thank this group for just inspiring conversation, for continuing to work innovatively to serve those who are not served. I have spent 20 years teaching primarily judges, but also lawyers and other system partners about best practices for working with self-represented litigants. There are thousands of things that people have come up with. And as I was teaching, I always felt like I was throwing things up on the wall and hoping they stuck. We had no data. We had no evaluation. Everybody was trying. It was good that they were trying. But to this day, who knows which of those programs, ideas, processes, forms, kiosks, name it, were effective. I would completely endorse Chris's suggestion, urging that if you have a good idea, it needs to be evaluated. It would be so extraordinary to teach and be able to say, this works. This would be valuable for you in your court. We have a couple of questions. One came in very early on when, Stacy, when you were discussing the statistics about served folks in the civil system. And the question was, are any tribal court numbers included in those statistics?
Yeah, those statistics come from the Legal Service Corporation's Justice Gap report. So it's a consolidation of data from all of the legal service organizations, and many of those organizations exist on tribal land and serve tribes. So yes, those numbers are included.
And we have a question about science. What are the type and range of variables you will look at as far as seeing if the modality will impact the broad spectrum of components of medical debt?
I suppose I should jump in on that one. And thank you for that question. Some of it is still being decided at the moment as we prepare for the evaluation that will launch likely in February, if not March. But I can say with certainty that there would be both subjective and objective outcome variables pursued. The objective ones would be pretty straightforward. Taking the intervention that I'm most familiar with from what the students did this semester, there could be a non-lawyer advocate program in which a person experiencing medical debt would have somebody on their side who is able to negotiate well with those holding the debt. And if we could find that most of the litigation matters that are filed end up being settled through that negotiation process and on terms that are more favorable to the person experiencing medical debt than they otherwise would have, that might be an example of an objective measure that signals improvement. Subjectively, we would be interested in knowing whether the sense of how the person with medical debt is being treated by the process, what a lot of scholars just call procedural fairness, whether that varies with the intervention, especially relative to the status quo of largely no assistance for a lot of individuals in this situation. Surveying them using validated tools that speak to procedural fairness would be an ideal way to, regardless of what happens in the outcome, even if the person does not get the result that they were hoping for, they still may feel empowered by the experience and treated with the dignity that they deserve.
Thank you. A great question. First, starting with a compliment about how great the projects are, but then how do you communicate the results or attempt to get the concepts adopted outside the test arena? Are they published or presented in conferences?
So I think that depends on the project. For the ODR evaluation, we've done a lot of publication and presentation. We do present about the program often, but some of our projects are live in the field. And so, for example, the medical debt work that we're doing now, the work is still happening. We're still evaluating it. So we do also do a lot of broad engagement with just media because we want to make sure the information reaches everyone and not just the academic world. So we have a lot of strategies around outreach and communication.
And another question about the medical debt project. Are you also working with creditors in that process?
Mackenzie, you want to answer that?
Yeah, so we have involved in our community outreach, we've talked to judges, we've talked to lawyers, both for defendants and for creditors. We've talked to creditors. We've spoke to hospitals, for-profit and nonprofit, and other community organizations that are helping people with issues related to medical debt. We've spoken to pantries, other community service providers, really just casting a wide net so that we can include a lot of different perspectives before we start thinking about ideas.
Thank you. What's been the most surprising change to your work as a result of the pandemic? Stacy mentioned a sort of a silver lining with the completely virtual lab, showed pictures of labs and other pets and children, and the combination of school work and your life. Other changes to the way you've had to do work?
I might say that although I try to hold myself to a standard of being, like I said, very thoughtful about how to construct an evaluation and launch it to ensure that the data that come from it are as useful as possible, COVID conditions really push you to be even more thoughtful about it. And I will say that I don't know that aside from some of the more complex randomized control trials that I'm involved in, that I've thought as intently about all of the variables that can now be controlled because of COVID, but those that can't. Going back to the Utah ODR experience that Sarah talked about with pivoting from live in-person evaluation to fully, well, not virtual, but much more truncated populations that we could work with, raised a whole host of issues for me about the validity of shifting from a truly representative group of participants to those who look like they come from the same population, but have a lot of different characteristics. And to our great fortune, because the four of us really thought about that so closely, I think we did a more than serviceable job of convincing the reader of the report that even though the second wave participants usually have not experienced the kind of small claims debt collection actions that the first group did, they have similar enough background and experiences so that the second version of the testing would be still viable.
Any other comments on surprising changes to your work during the pandemic?
I think one thing that has been surprising and really amazing is I4J has been able to bring in a lot of different people into the lab that we might not have been if we were bringing them into the classroom. I mean, we've had so many different collaborators come into the classroom to teach our students, and also just being able to engage with so many people in Utah that we might not have reached if we were just working like boots on the ground. And I think that will help us with strategies moving forward, even once COVID is lifted. So I'm excited for that.
And to dovetail on Mackenzie's idea, as somebody who works in online education, I've been working with plenty of collaborative online teaching tools for years. And I'm now seeing these tools embraced by the general public as a way to continue to connect and collaborate and be innovative, even when we're separate, but finding ways to come together in our online environment. And that's wonderful to see that normalized in some ways. And I'm sure spur a much more development in ways that we can continue to connect and relate.
And I'm sure everyone watching this wished that we all had a tutorial from you, Sarah, to become expert in this modality. I'm going to have you on speed dial. Another question, what are the next opportunities for innovation?
All of them. I think I'm not sure there is a social justice issue in the world right now that wouldn't benefit from innovation. And I would just second what Sarah said about risk and opportunity, that the issues that COVID has highlighted are heartbreaking and also have made us all take a hard look at our capacity to deliver change. And so, I hope that we'll take advantage of that opportunity to explore both service change and policy change that is going to meet the immediate need, but also become lasting change in how we connect people with their civil legal system.
I would put in a plug for some things that I4J has been very strongly connected to in the innovation space, both the opening of legal advice provision to non-lawyers, which is a big part of what we're working on in the medical debt context. And then again, the digital space of online dispute resolution. I think many of us are all too aware of processes and just ways of living that were upended earlier this year, and that we realized we may not have to continue doing, even when the world becomes a safer place to move around in. And in the civil justice realm, the criminal justice space, the same thing is true. Long-held beliefs, opinions that, again, aren't always based in strong evidence have, by necessity, been changed. And I think that any area in which there aren't enough licensed attorneys to go around, but other folks who have different backgrounds and skills could be certified to work with potential clients is a great avenue for innovation, again, led by this lab. And any chance to use technology for good, to make it easier for people who can't otherwise get off of work, find childcare, travel to a courthouse for that physical interaction. And now knowing from the ODR evaluation that far more people, if not almost everybody, I think, if not everybody in that evaluation, would prefer to handle some types of matters at their own convenience, still with all the protections that the law affords, but on their own time, in their own spaces, so that they can still live the rest of their lives. any opportunity to think about that is one that we should be taking. It doesn't really matter what the subject matter is, just as long as we're looking for ways to make legal processes more efficient and more effective at the same time.
Finally, what is the most important thing that folks working in the system or hoping to work in the system in any capacity, and I'm talking the justice system writ large, lawyering, probation, advocacy, all of the ways that work impacts the system. What's the most important thing those people need to know about the importance of innovation? Why should they care?
I'm going to steal Sarah's answer and say that I think one of the most important takeaways of the work we're doing is to build for your user, design for your user, and listen to your user. These are systems that are meant for our people, and they're not working for them. And so if you do one thing in whatever you do after this presentation, it's take a hard look at who are you serving, and are you serving them in the way they want to be served?
And to continue on that theme, I encourage everybody to embrace human-centered design techniques. You can glean important insights from your target audience, regardless of who you are. You don't have to be, have a degree in UX research or empirical science. Although we're happy to help. If you have ideas, please reach out to us. But it's something anybody can do. You can just start by talking to your users, as Stacy said, and really listen to them, understanding what their pain points are. If you have a help desk related to, the service that you provide, they're often a wonderful resource to help you understand where people are coming across problems with the service or system or website that you're related to. Website analytics are really informative. They can be intimidating, but there's a wealth of information in there about where people drop away from a process because they've gotten frustrated. And just observing people using your technology is really informative. You don't even have to have an official usability test, although I recommend it. But if you've ever sat next to somebody and helped them step through a process, you realize everybody uses technology differently. And so watching people use your technology and seeing where they run into issues or challenges or confusion is really enlightening. You can gain plenty of insights just from pure observation. So if you do want to go this next step and do usability testing, we do encourage that you compensate your participants. That's one point that we really want to make, that we did compensate all of our lived experience participants in this study. And there are lots of resources out there to help you if you are interested in learning more about human-centered design, UX, usability testing, et cetera. So we can pass that along to you as well. But yes, please, just main point, think about your users and involve them in everything that you do, and you will create a better service in the end.
Thank you. We are just about out of time. I wanted to thank everyone for attending today, for the great questions, I'm assuming you were all listening attentively. It's really hard to judge when there's no sound and no pictures, but I'm assuming the best. And I hope that you continue to watch for future LawCat Live programs. Stay healthy and have safe and peaceful holidays. And there are 2 links to the reports mentioned by Sarah and Mackenzie. If you click on those, you'll get CLE credit if you need CLE credit. And also you will be informed by the vast amount of data and the terrific conclusions they were able to draw from those amazing projects. If you want to stay on the call, some of the panelists are able to do that. Others have to go on to other obligations. But again, thank you. And we have a couple more questions. Oh, it's people thanking us.
I think it's just praise.
One of the other comments was about working in parallel alternative service provision in healthcare and medical services, and work in parallel, look at the pros and cons of each to synergize. And I wanted to comment that during the class I assisted with, we actually brought in representatives from other professions where alternatives to traditional service provisions had already been utilized often for decades. For example, behavioral health, you don't always get a psychologist. Sometimes you would have a master's in social work or other master's level therapist. We talked to the dean of the medical school about non-doctor, I've lost my words, physician's assistants and nurse practitioners, and those folks have been involved in medicine again for years and years. And the legal profession is a little slow on coming up with a similar kind of a parallel practice. It's not to say it's not something that we should be doing. And we did have a question about paraprofessionals. So perhaps, Stacy, you could talk about the paraprofessionals in Washington State and Utah.
Sure. Yeah, the question was just what thoughts do we have about paraprofessional efforts that are emerging in other states? Washington was the first state to create a kind of new tier of legal professional. That program has actually closed fairly recently, earlier this fall. But in the meantime, Utah has launched a licensed paraprofessional program, and Arizona has one on the books, but not yet live. I think I4J's perspective is that we know we won't ever serve all the legal needs with attorneys, and that we do need to think creatively around who else can be trained and qualified to provide legal services. But we also believe that those efforts need to be well designed with and within the community. So we do have two, Chris talked about the medical debt pilot that we're working on now. We also have one in Arizona involving domestic violence. Both of those efforts are looking at who are the people in the community who already have a lot of boots on the ground knowledge about how the civil legal system works, who just need a little extra legal training to be able to really effectively help the people they serve with their civil legal issues in a limited scope capacity. So my biggest takeaway is we have to involve the community in those discussions. That's something we have not done very well as attorneys to date. And new service models need to include the public in decision-making.
We have a specific question about San Diego. If anybody on the panel knows what resources might be available in San Diego, or where should this questioner look for those resources? Also, what are the national resources that provide data nationally and regionally?
I think that might be for me as well. I don't have San Diego specific resources other than to say that the University of San Diego Law School has a really great Center for Public Interest Law. And I have a colleague there who's been very involved in the regulatory reform effort. And I know that there's a really, really innovative pro bono program in San Diego that I think is called the San Diego Volunteer Lawyers Program, but I'd be happy to follow up. Nationally, there's a lot of sources for access to justice statistics. I mentioned the Legal Service Corporation's Justice Gap Report. Many states now are producing their own Justice Gap reports. The Self-Represented Litigation Network has a wealth of resources about what the world looks like for self-represented litigants. The National Center for State Courts, the National Center for Access to Justice keeps something called the Justice Index that will tell you how your state is doing on various access to justice fronts. So those are a few that you could start with.
And if you go to the National Center for State Courts website, you will find links to what's happening in specific communities. And I happen to know that San Diego has a robust self-represented litigant self-help kind of a program that's been going on for a really, really long time. They have all kinds of things in the courthouse and outside involving lawyers coming in and helping in the courthouse. So I would start there. And it's great that you're interested. We have a request to talk more about access to justice issues in Arizona.
So I'm not sure where you want us to start. Arizona has the Arizona Supreme Court has a very active Access to Justice Commission that has been around, I think, since 2014. And they've done a lot of great work. They've been very involved in our AZ Court Help and our AZ Law Help websites. We have 3 Legal Service Corporation funded legal aid providers in Pima County. We have a freestanding pro bono center, Step Up to Justice. The Arizona Supreme Court formed a commission, a task force on legal service delivery in 2019 that has made a number of recommendations about how to innovate how legal services are provided, but really with a goal of improving access to justice. So I think we're trying really hard. We're doing a lot of good things, but we're a state with a lot of poverty. Tucson is a city with a lot of poverty, and with poverty comes access to justice issues. So we have a lot more work to do.
The question was clarified to be access to justice in Arizona with your work.
So not just all of access to justice in all of Arizona. Okay. We have a lot of work happening in the eviction space. We have 10 education workshops that have been running since 2018. We do a lot of community-based advocacy around eviction. I think our kind of big headlining Arizona project right now is our licensed legal advocate pilot, which is the regulatory reform project in the domestic violence space that I mentioned, and that Judge Adam helped us launch and continues to be very much involved in. And that project is training lay legal advocates at a DV service provider to have adequate legal training to be able to provide limited scope legal advice to the survivors that they serve around protective orders and family law matters. So that's, I think, our project that's putting Arizona on the map. That's the first project in the nation that is taking that opportunity to amend unauthorized practice of law and applying it specifically for the nonprofit social service sector.
We have a few more minutes if anybody wants to ask another question or two, or if there's anything our remaining panelists would like to add to what they've said.
I have one last thought that I didn't want to say earlier. Sarah and Stacy were both talking about one takeaway that they want innovators to have. And they were both talking about embedding human-centered design and really talking to the people you're building for and involving them in the creation of solutions. But if you're interested in getting involved and you don't yet have a solution that you want to take to people and you want to involve users, I've learned very quickly that there are a lot of people in this community and in the access to justice community who are already doing amazing work. So if you have an idea, like a topic or a focus you want to get involved with and you don't know where to start, my best advice would be to reach out to the people who are already doing the work and start talking to them. Because when we were doing eviction-related work here in Tucson, I was absolutely blown away by how many people in Pima County, right here, the University of Arizona, were working ridiculous hours to try to keep people's house. And when you brought those people together, the share of resources and the work product that came out of that was just incredible. So find your innovation friends in your circles and work with them.
Thank you, Mackenzie. We should all feel good about the state of the profession with such talented and committed young lawyers ready to go in and shake everything up and hopefully bring some of us longer time practitioners along for the ride. It's an exciting time to be part of this. I'm very grateful to all of you for sharing your ideas. And we look forward to seeing what it is you do next. Thank you all. And we will end the LawCats Live now. Thank you.